Yes, Ms. Weston, was there anything else?
Simply to clarify that in response to my learned friend's perfectly appropriate inquiry, we do and have argued that Mathieson,
I'm so sorry.
sorry, my lord. We do and have argued the ground too that that Mathieson is relevantly analogous, not on all fours, but analogous.
Yes.
But
well, really, the way your grounds work is that one is a sort of portmanteau ground.
Yes.
That, they all got it wrong.
Yes.
And into that, I suppose you can fit pretty much anything.
Yeah.
And you've given us your argument, which is
Yes.
essentially a justification one. And ground two is to do with all the status points.
That's.
And you don't abandon any of them.
No, and but the only point that we have abandoned is the 16 and 17-year-olds as comparative.
All right. Well, just so we can be specific about that, that is in the amended grounds of appeal is number.
Number ground 3 in the amended grounds.
The very last paragraph
Yes.
of the grounds of appeal we can ignore.
Yes. Well, so obviously justification is an issue, but the point about the comparator of 16 and 17-year-olds is
right,
not.
But just so to make sure that I've got this right, justification comes in under 1.
Yes.
And the status points come in under 2.
Yes.
Right. Thank you very much. Just a moment. Yes, Ms. Cloud.
My lord, yes. The way I intend to structure my submissions is as follows. First, I'd like to take your lordships and your ladyship through the statutory framework. I can do this at quite a high level, but the points that I want to make are to show the court how Parliament has created and repeatedly endorsed what we have termed the hospitalisation rule. Second, I want to take the court to the key provisions of the Mental Capacity Act so as to demonstrate how courts in this jurisdiction make a finding that an individual lacks capacity to make particular decisions. And I say that can only be done under the Mental Capacity Act. It cannot be divorced in the way that Ms. Weston is suggesting. And third, I want to focus on the legal framework around deputies, as that has played such a significant part in Ms. Weston's submissions, and how decision-making takes place in respect of those who lack capacity. Because as I know my Lord Justice Peter Jackson will know, it is not only through the appointment of a deputy. Indeed, that is very much the rare and unusual occurrence. But in short, we say that deputyship is about taking decisions on behalf of P. It does not require the deputy to provide care to P, or indeed to carry out any of the tasks that Miss Weston now relies upon as justifying the differences in treatment. We also say that a lay deputy is not entitled to be remunerated out of P's estate for performing that role. And so DLA is not put into payment in order to pay a deputy for acting as such. Indeed, it couldn't be used as such. My second heading is then to go on to identify 9 key principles that can be derived from the Strasbourg and the domestic case law under Article 14. And I will then show the court 4 authorities to make good those propositions. Then I will turn to make our submissions, but if I can give our outline points now so that the court can see where I am going. On status, and I will touch on that briefly, but only briefly in light of your lordship's indication, we say that a lack of capacity to make a decision, or a functional inability, as Ms. Weston puts it, to make a particular decision at a particular point in time about a particular act is not capable of being an other status for the purposes of Article 14.
Would you accept that if it were a permanent incapacity to make a decision for oneself, that might be a distinction?
It might be, my lady, but the courts do not ever grant a declaration that there is a permanent inability to make a decision on a certain...
I can see your point in relation to temporal incapacity. I think we can all see that point, because you may have a capacity on day one and not a capacity on day two. But there may be situations where, unfortunately, as with the young man in this case, the reality is that he's never going to be able to make any decisions for himself, and that was why a welfare deputy was appointed. Now, speaking entirely for myself, I can see an argument that if somebody has a welfare deputy appointed, that could be seen as a proxy for the type of severe impairment which requires the decisions to be taken for him, and therefore that could be amount to a group which has a status for these purposes.
Well, lady, I do accept that, but when we go to move on to look at the Mental Capacity Act, which I'll come to in a moment, there is no category that can be formulated in that way, because even when there is a deputyship order, the deputyship order itself provides that the deputy can only make decisions on behalf of P when P does not have capacity to make those decisions for himself. So no court under the Mental Capacity Act will ever make a finding that P can never recover capacity or may not be able to make a decision about a certain kind of thing.
If you take Tony Bland, he is in a assistant vegetative state and has a lifespan in terms of years. I mean, it's a bit meaningless, isn't it, to say, well, because nobody could ever say he's permanently lacking capacity, he doesn't. Of course he does. Aren't we meant to be looking at the reality of these things and not just labels?
But, my lord, there is, of course, a very wide spectrum of people who either lack capacity at a particular point in time.
Of course, one has people who have fluctuating capacity, and one has tragic situations where somebody's never going to have capacity. Some cases where people never have had capacity.
Yes.
And never will. So there would, at least, I think, be the sort of distinction that my ladyship mentions between cases where it might be, as Judge Ward said, in and out, as it were, of capacity, but there will be cases where I'm afraid it's definitely incapacity.
But, my lord, I accept that. There will be some people, as you say, those who are in, say, the persistent vegetative state, they're never going to be able to make.
Well, I took an extreme example. There are much less extreme examples of people who are sadly never going to recover capacity.
Yes,
I mean,
but there are many.
One might consider the appellant in this case to be one of them.
It may be, my lord, but when one looks at particular decisions, does he want that drink or that drink? Does he want that food or that food? Would he like to move to this place or that place? These are all decisions that he may well have capacity to make for himself, with the right support, with the right kind of explanation, and with someone who can understand his communication. Because that is indeed what MG is saying, that she can understand his needs and what he wants. So one can't say that he will never have capacity to make any kind of decision about any kind of thing at any point in time. And that's the difficulty. There'll be a very narrow category of people, as your lordship has identified, who could perhaps fall into that box. But the vast majority of individuals who are in receipt of DLA, which is what we're concerned with here, and are affected by the hospitalisation rule, one couldn't put them in that box.
No, well, that I can understand. But it is what you're saying, that you cannot use the appointment of a deputy of this nature as a proxy for a certain state of understanding or lack of communication, which would afford you, if you like, a means of identification of a group within profoundly disabled people. Because my understanding, and it's much less than that of my lord, is that you wouldn't get a welfare deputy appointed unless you get to the stage where somebody is either incapable of making the decision for themselves on a permanent basis or can't communicate the decision if he is.
I think it's even more extreme than that, my lady,
Yeah.
in the sense that the difficulty with using deputyship as a status is that you may have individuals who have the same level of need, the same lack of capacity, but there isn't a family member who is willing to be a welfare deputy and so can step in and wants to hold that role. So one
then
may
the court
have...
would appoint one from outside the family.
Well, my lady, that's not generally the... It's very rare in the first place to ever have a health and welfare deputy. That's point one. But point two, in 20 years, I have never seen a health and welfare deputy who was not a family member. One simply doesn't appoint, say, local authority social workers or a trust corporation to make decisions about welfare. One may appoint them to make decisions about finance, so that's a property and affairs deputy, which is a different thing, but one doesn't see that for people who don't have close family members who are closely involved in the lives of P, for whom they are making decisions. So one could, it's not the fact that if you have those individuals, it's not that those who have the most serious and significant needs will automatically get a welfare deputy. That's not the way that the court approaches it. And I'll show your ladyship in a moment, that's not the way that the Act and the legislation approaches it.
So, Ms. Claimant, I don't want to dwell on this, because I know you were actually only giving us your headline
Yes,
points.
I was. I thought it would help to set out my headline points. I should have kept my powder dry.
It is helpful, but if at some point you're going to return to the question of status, simply because I think in fairness to you, I should, as it were, as my lord put it earlier, lay my cards on the table. I have to say, speaking only for myself, that I regard debates like this as being perhaps more suited to the Chancery Division than to the human rights context. And I recall the famous words of Lord Wilberforce in Fisher more than 40 years ago, that in the field of human rights, one should avoid what he called the austerity of tabulated legalism.
My lord, I entirely agree. I'm simply giving your lordships and your ladyship my headline points. I didn't intend to spend more than 5 minutes on status when I come to develop it, because I see the focus of this dispute as lying in the nature and extent of the comparative exercise that needs to be carried out for indirect discrimination and Tliminos discrimination and or objective justification. But I do have to lay down the Secretary of State's marker that she does not accept that lack of capacity or appointment of a welfare deputy can ever be accepted as a status under the Strasbourg jurisprudence. But I entirely take on board, my lord, the point that your lordship is making. My lord, going back to my headline points, in terms of discrimination and the comparative exercise that needs to be carried out, we say that whatever other status is ultimately settled upon, the factual findings made by the judge mean that the appellant cannot establish any form of indirect discrimination or Tliminos discrimination. And Miss Weston didn't even address this, but I say it is a very important point, and this court does need to grapple with it. Third, I say even if the appellant can get over that hurdle, then we say the judge was right to conclude that that this rule, the neutral hospitalisation rule, is objectively justified. And there was no error of law in his approach. If your lordships and your ladyship were against me on that, then I would still say there are no factual findings that need to be made, but this court can simply apply a different test if the court thinks that that is the appropriate approach.
Again, can I just flag a question I have, but please don't take it out of turn now. Could it not be said that the judge obviously fell into error as a matter of approach because he asked himself the manifestly without reasonable foundation question? He wasn't to blame for that. That's what everyone thought the law was at that time until SC in the Supreme Court enlightened us all. If that's right, then don't we have to do the evaluation of proportionality again in accordance with SC?
Well, my lord, first I say that while SC says there is a more nuanced approach in the sense that one can't automatically apply the manifestly without reasonable foundation test when one is in the field of social security law, what Lord Reid does say is that that will ordinarily be the test if one is looking at non-suspect grounds, that you are in the field of welfare benefits and one is concerned with measures that have been adopted and endorsed by Parliament.
Yes.
So I say that manifestly without reasonable foundation is still the correct test after SC. Judge Ward didn't know that there was a discretion about which test to adopt, but he adopted the right test. So I say he didn't make an error of law. But if your lordship is against me on that, then my fallback position is the one that your lordship has put to me. And I say there should be no difference in outcome, because what Lord Reid was clear about in SC is that there is no difference between Bank Mellat and very wide degree of judgment and manifestly without reasonable foundation.
Look, I sincerely mean this. I don't want you to dwell on this now and take things out of turn. But it seems to me, and I speak only for myself, that this area of law has become bedeviled with conceptual debates, which are frankly arid debates. And the true question, certainly to a human rights lawyer, the question of substance is usually, is what the state has done objectively and reasonably justified? And speaking only for myself, I wish we would just grapple with the true substantive question.
My lord, speaking personally, I have a degree of sympathy with that. The Supreme Court, however, has said that the test is rather more nuanced. But what I say
I'm not disagreeing. Forgive me. I'm not disagreeing with anything the Supreme Court has said.
My lord, absolutely. I think there are a number of hoops and conceptual labels that one can put on these things. But I do agree with your lordship. That is the question. But in my respectful submission, it's not whether this court thinks that the measure is objectively justified.
It's whether the judge was entitled to.
It's whether you think it is objectively justified, paying the appropriate degree of deference, although that is an outdated term.
Respect.
To respect, that's right, my lord, to the Secretary of State and to Parliament, which has specifically endorsed the hospitalisation.
Exactly.
But my lord, I entirely agree. That's ultimately the task that this court has to embark upon. But in my submission, that is the task that Judge Ward embarked upon. We say he applied the right test and he got it right. And there is no justification for this court with respect
well, now
to
you've set out your sorry, speak over you. You've set out your stall.
Yes.
What's your estimate in time for running through those matters without unreasonable degrees of disruption?
Well, I thought my introduction was going to take 10 minutes, but that's taken rather longer. I'd hoped to be done in a maximum of 2 hours to give Miss Weston some time for reply.
Well,
I will speed it up.
You're not going to have 2 hours. We're going to be sitting in normal circumstances until 4:15.
Oh, my lord, sorry, I meant from 2 o'clock, so...
Yes, well, we're going to allow time, of course, for a reply, and so you're going to need to be finished a bit before 4. And my experience is anything to go by. If you manage to deal with it more shortly, it's almost certainly going to be more helpful to us.
My lord, I'll take that hint on board.
Right.
In terms of the legal framework, I can deal with this very quickly. My lord, one knows how the regulations themselves were introduced. They were made under the Social Security Act 1975. Just for your lordship's note, it's in tab 2 of the supplementary bundle. This is the overlapping benefits provision. It provides the various to make distinctions when individuals enter into hospitals.
Right. So, from what year has that been the arrangement?
These were made under the 1975 Act. That provisions like this have been in place since the welfare state was set up, and your lordship sees that reference supplementary bundle, page 95, paragraph 14. That is the witness statement of on behalf of the Secretary of State, which confirms that provisions like this have been in place since 1945. My lord, to deal with the point made by Lord Justice Singh earlier today about what is the purpose of disability living allowance, it makes a contribution towards the additional costs arising out of a benefit claimant's disability. And my lord, you see that, the same page, supplementary bundle, page 95, paragraph 12. That again is in the witness statement from the Secretary of State. My lord, the regulations that were made under the affirmative resolution procedure, so they were specifically endorsed by Parliament. The 1975 Act has been repealed. It was consolidated in the 1992 Act, which is in tab 3 of your supplementary bundle, section 73, and the regulations...
Do you mean supplementary bundle? Or...
The supplementary authorities bundle, my lord, this one that we have.
Oh, I see, right.
I do apologise.
So you've given us those in here. That's
Yeah,
helpful.
so it's,
Thank you.
it's tab 3, section 73, and the regulations that were made under the earlier Act are treated as though they were made under the later Consolidation Act. The regulations were amended after the Supreme Court's decision in Mathieson to change the provision with respect to children. Those amendments were made under the negative resolution procedure, but again, no issue was raised in respect of them and they took effect. My lord, that's all I wanted to say about the primary legislation.
Has it always had the 28-day exception?
The 1991 regulations have. For children, it was 84 days.
Yes.
So
What's the rationale for allowing duplication of cost for 28 days?
I think, my lord, I don't think there's any specific evidence on that, but my understanding is that it is simply to deal with the short-term, the relatively short-term hospital admissions.
Yes, that's what I'd assumed.
So if one is paying for a care package at home, one doesn't want to lose that.
Well, you see, it may be significant later on to the bright lines argument, that otherwise you'd have to go into individualised consideration. And so maybe, it's a bit like, the taxpayer is usually entitled to claim the times as a relief, as an expense, even if they don't in fact take times, because the HMRC can't have to investigate every taxpayer to see whether, sorry, when I say every taxpayer, I mean every lawyer who's a taxpayer. They always say, I take the law reports and therefore I need the times. If you had to investigate every case for small amounts, then...
Gosh, I never knew you could claim for the time. You're missing something for many.
Well, when I acted for HMRC, that was undoubtedly the practice.
My accountant considers that still the rule, my lord. Yes, it's a short-term measure to deal with the sort of short-term hospital admissions and to not impact on what's in place in the community during that short-term hospital admission.
Right.
My lord, we have seen the regulations themselves. Unless it would assist the court, I don't propose to go through the terms. They're treated differently. The care allowance the care element is deducted under Regulation 8, the mobility under 12A, but I'm not going to take time going through that. My lord, if I could turn to the Mental Capacity Act, which is in the Authorities Bundle at tab 2, starts at page 15.
Right, so this is your second topic.
My second topic under the statutory framework, my lord, that's right. And we haven't looked at this, and I think it is important to understand how the Mental Capacity Act works. So tab 2, section 1 sets out the principles that apply for the purposes of the Act. So subparagraph 2, a person must be assumed to have capacity unless it is established that he lacks capacity. So my point is, if there's a status argument based on capacity, someone has to produce evidence to show that an individual doesn't have capacity before that finding can be made. Section 3, a person is not to be treated as unable to make a decision unless all practicable steps to help him to do so have been taken without success. That's not only the deputy, but that's in respect of any person who is making decisions on behalf of P. And then subsection 5, an act done or decision made on behalf of a person who lacks capacity must be done or made in his best interest. Section 2 and 3 are the key provisions that identify when a person lacks capacity. And one sees 2.1, a person lacks capacity in relation to a matter. So it's not a generic one lacks capacity. It's got to be something specific. If at the material time, so again, it's not a decision that one lacks capacity forever, he is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the function of the mind or brain. And subsection 2, it does not matter whether the impairment or disturbance is permanent or temporary. So again, that's my point, that one can move in and out, and it will depend on what is happening to that individual on a particular day and the nature of the decision. And section 2, subsection 4, in proceedings under this Act or any other enactment, so whenever one is determining whether there's a lack of capacity in respect of a decision, any question whether a person lacks capacity within the meaning of this Act must be decided on the balance of probabilities. So there's a very specific process set up. Section 3 then deals with an inability to make decisions. When is a person unable to make a decision? And one sees there, for the purposes of section 2, a person is unable to make a decision for himself if he's unable to understand the information.
Yes, we can see what appears there.
Yeah. And my Lord, I just draw the Court's attention to subsection 2. I know your Lordship will be familiar with this, but it's that steps have to be taken to explain the decision in a way that the person can understand. And again, subsection 3 emphasises the fact that one can move in and out of having capacity in respect of a certain decision, the fact that one's only able to retain the information for a short period. And my Lord, the rest of these sections are in tab 1 of the supplementary bundle. So section 4 is best interests.
Right, what sub-paragraphs do you want us to look at?
Subsection 4, my Lord.
Right. Yes.
And then section 5. And section 5 is important because this section is the section which usually enables, in the vast majority of cases, enables decisions to be made in respect of P's care and treatment. One doesn't have to have a deputy, one doesn't have to have a court decision. In the vast majority of cases, decisions will be taken under section 5. And what section 5 does is it provides a defence to the person who is delivering the care or treatment to P, or is making decisions for P, from incurring liability. So a carer, or a nurse or hospital staff, will usually make best interest decisions in respect of a P who lacks capacity, and they do it under, they deliver the care and treatment under section 5. So subsection 1, if a person does an act in connection with the care or treatment of another person, section 5 applies if D takes reasonable steps to establish whether P lacks capacity, and D reasonably believes that P lacks capacity and it will be in his best interest for the act to be done. And it's subsection 2 that gives the defence, it gives the shield. D does not incur any liability.
How is this helping us?
Well, my Lord, it's the point that one doesn't need to have a personal welfare deputy to make decisions.
You can say that in a sentence, we all know that.
I wasn't sure whether everyone did know that, my Lord. I do apologise if that's the case. But it's also making the point that when there is a deputy, one doesn't need to have a deputy there to make every decision in respect of P.
Yes.
And this is section 6, which is over the page. So a person in the hospital providing the care to P can deliver care or treatment under section 5. The only limitation is 6, subsection 6. Section 5 does not authorise a person to do an act which conflicts with a decision made within the scope of his authority by a deputy appointed for P by the court. So the care providers can't do something that the deputy says you can't do or you must not do, but they can do anything else.
I'm not sure, I'm afraid that this is really meeting the gravamen of Ms. Weston's points. First of all, she says it doesn't matter if you don't always have to have a deputy. Well, you do have a deputy. That's something that is significant. And secondly, she says, well, all right, it may be that they don't have to be there all the time, but that for the better integration of a person with such a severe impairment into society as far as possible on an equal basis, that it's better if MG is there because she understands what her brother's trying to say, that when he does the thumbs up sign, that may not in fact be assent. I think nuances like that which may be missed on the nurses.
My lord, I agree with that and I accept that. But one has to step back from this and say, what is it that that MG was required to do? And Miss Weston says as part of her role as deputy, she was required to do a large number of things. I say that's not right. What a deputy is required to do is to take decisions on behalf of P, and I'll show your lordship that in a moment. That comes from section 19 of the Mental Capacity Act. And that while MG, obviously because she loves and cares for her brother, she plays an important role in his life, and it is very commendable what she does for him. Of course, the Secretary of State doesn't dispute that for a moment, but it's not a requirement, it's not a duty imposed by statute, and one can't assess the validity of a rule, a general rule that Parliament has enacted, by the way that an individual acts in a particular case.
Yes. You're going to take us to another section of the Act.
I am, my lord. Section 16 of the Mental Capacity Act is at
Back in
page
the bundle.
19, back to the main bundle.
Yes.
And again, the two distinctions, if P lacks capacity in relation to personal welfare or property and affairs, either the court may make a decision on behalf of P, or the court may appoint a person, and one sees 16.2a, to make decisions on P's behalf in relation to the matter or matters. My lord, one then sees section 19, one turns on a few pages, appointment of deputies, and 19.6, Miss Weston said the point of deputy is to give agency to P. In my submission, that's not what section 19.6 is about. It deems the deputy to be P's agent. So if the deputy enters into a contract on behalf of P, he does it as P's agent. It's not, the purpose of this is not to give P agency in the sense that Miss Weston.
Well, no, I mean, I'm just expressing a concern about dancing on the heads of pins. The framework of the MCA is, I know, understood by the court, and that it's, as you say, I think we've probably finished our survey, have we, of the
I have,
but
yeah.
I can assure you that this is not going to turn on a precise form of words. It's to do with what the Act is there for, what deputies are there for, and we'll have to form our own view about that.
My lord, I'm grateful. So moving on then to the next item on my list, my 9 principles from the Article 14 case law.
Right, well, could you just list them, and if we're interested in any of them in particular, we'll ask you about them, and if you're interested in any of them in particular, you'll tell us.
My
So
lord,
let's
I'm
just
very
have the
grateful.
list without interruption.
Point 1, legislation cannot be framed to address particular cases. Legislation must lay down general rules. These are bright line rules which are important so that those administering the scheme can quickly and effectively operate it. So when one is considering complaints of alleged discrimination in a welfare system, the courts are concerned with the compatibility with Article 14 of the system, not with individual facts or how particular individual claimants might be affected by the legislation. My lord, I'm not going to turn this up, but that comes from Carson and UK. It's in the supplementary bundle, tab 5, paragraph 62.
Thank you.
I don't believe that point to be controversial, but it's an important one. Point 2, again, not controversial. Article 14 doesn't apply unless the discrimination is within the ambit of a convention right and on a ground stated by Article 14. Point 3, when assessing whether a ground amounts to an other status, it is common ground that in recent years, both Strasbourg and the domestic courts have taken a generous approach. I don't dispute that. But we say there are still limits to what is an other status. And I will come on to that when I make submissions about it. Point 4, which is important, there must be a difference in treatment between the claimant and the relevant comparator. There are 3 kinds of discrimination that the Strasbourg Court has recognised: direct, indirect, and thlymenos. Miss Weston does not rely on direct discrimination. She relies on indirect and thlymenos. Now, for there to be indirect discrimination, there must be a general policy or measure that applies to everyone and has a disproportionately prejudicial effect on a particular group. And that particular group will be those who have the status that is relied on. What we have here, and what the Upper Tribunal had, is the facts of one individual case, and the judge found as a fact that there was no disproportionately prejudicial effect on the appellant of removing disability living allowance. You have no evidence before you at all about the impact of this rule in any other case. I'm still on my point 4, but thlymenos discrimination means a failure to treat differently persons whose situations are significantly different. And again, we say, the judge found that that element of discrimination failed on the evidence the individuals relied on are not in significantly different situations. So point 5, if there is indirect discrimination or thlymenos discrimination, one moves to the question of objective justification. So as to not get bogged down into compartmentalisation or arid disputes, the court can just look at it under objective justification, I accept that, but then all the points I make about comparators go into the objective justification analysis. Sometimes the court just skip that middle stage and go to the last one. But in the when one is dealing with indirect discrimination, I do say it's important to do the first stage, the comparison stage. Point 6 is what is the test for objective justification. I think I've outlined that in response to my Lord Justice Singh. Before SC, when one was dealing with welfare benefits, the test was always, is the measure manifestly without reasonable foundation? After SC, that is no longer automatically the test, but SC says that where the claim alleges discrimination on a non-suspect ground, where the claim challenges a long-standing piece of legislation which has been repeatedly endorsed by Parliament, and where the challenge is to a decision of social and economic policy in the field of welfare benefits, which is concerned with the allocation of resources, then we say, SC says the test is still the same, it is still manifestly without reasonable foundation.
Right, and what's the paragraph number for that?
My Lord, I'm going to take you to SC in a moment. It comes from paragraph 157 through to 161.
Thank you.
Point 7 is the limited role of the appellate courts when reviewing a decision of lower courts on an issue of proportionality under the Convention. If the judge applied the correct test, the role of this court is not to second guess his decision, it's not to carry out the balancing exercise afresh, it's simply to ask, was the judge wrong? And there is also a reluctance to interfere with decisions of specialist tribunals. Point 8 is Allah and the mirror principle. I know the court is aware of that. And point 9 is the role of unincorporated treaties. It's now common ground with Ms. Weston that after SC, the courts cannot determine whether there's been a breach of the UN Convention on, with respect to persons with disabilities. So, my Lord, I'm going to take you very quickly to the 4 authorities that I rely on to make good those propositions.
Just before you do, taking up my Lord's invitation to say what I at least am particularly interested in, your 6th proposition.
Yes.
I'm sorry, my Lord.
Your 6th proposition.
Number 6, yes.
Suppose you had all the features you've mentioned, right?
Yes.
Long-standing piece of legislation, social and economic policy, welfare benefits, allocation of scarce resources. But the discrimination is between men and women, or between black people and white people.
My Lord, then it becomes more difficult. It is not as straightforward for me to say it's manifestly without reasonable foundation. SC leaves open then, with those suspect grounds, the question of whether one then goes into Bank Mellat and adopts a much more intensive scrutiny. But that is not this case. We are in non-suspect ground territory because the status relied on is a not just a severely disabled adult. I accept there'd be some difficulties with that, whether that's suspect. But it's a severely disabled adult who's been in hospital, an inpatient in hospital on a long-term basis, and who either lacks capacity to make decisions about his care and treatment or has a personal welfare deputy. And that, I say, is a very long way away from the suspect grounds that Strasbourg has identified. Indeed, it's never been a ground that Strasbourg has identified.
Well, you may be right about that, but I put this point to Miss Weston, and she very firmly replied, yes, it is. She says it's analogous to what Lord Reid was talking about in paragraphs 112 and 113,
yes.
Because it's disability related, and it's about a very vulnerable category of people who, for example, can't communicate what their true needs are.
My Lord, I accept that, and if the status were just tied to disability, I accept that there's some case law to suggest that that may be a suspect ground. But we're not just looking at disability here. It's disability and any number of other things which are tied into and reflect the legislative rule that Parliament has adopted. This isn't just saying this individual is a severely disabled individual, let's compare him with someone who doesn't have his disabilities. It's severe disability in hospital as an inpatient for a long period of time, and the element about lack of capacity. So it's, even if one accepts lack of capacity as being a status, and I'm not conceding that for a moment, but even if one does that, it's not purely disability. There are all number of things that are added into that status to get Miss Weston's claim off the ground.
Well, it seems like an awful lot of hard work has got to be carried out to decide whether something is or isn't a suspect ground, which is itself no more than a construct to aid thinking rather than to channel it. One can easily see that there is a difference between somebody who would get DLA on the basis that they were gravely physically disabled, take somebody like Professor Hawking, and somebody who is in the position of the claimant in this case, who is gravely disabled. But part of his disability is an inability to communicate effectively. Now, I mean, why should one split hairs about what sort of disability somebody has? I mean, to say that a ground is disability and that's an end of it, either you're within that camp or you're not in it and you're just another ground, is a very crude way of approaching discrimination law. It just simply depends how closely you look at the category. So I think it's that sort of reason that makes us, as you have gathered, somewhat impatient.
Yeah, my lord, and I entirely agree. There are a lot of hoops that one has to get to before one even gets to the substance of the argument in this case. But the way I say it works is one has those statuses that are suspect, that Lord Reid has identified as being suspect in SC.
Well, we don't know what Lord Reid would have said about this case.
Well, my lord, we don't,
Well,
but we know...
We've got to make our own decision about it,
but we know the examples that Lord Reid gave of being characteristics that are innate, that can't be changed, that are very personal to the individual, like sex, like race, like disability. But what we have here is not a status based on disability. Miss Weston can't get home by showing the status is disability and that's the reason for everything that's happened. It's not. It's not whether the person is disabled. It's adding in the neutral element of and has been in hospital, a long-term inpatient in a hospital. And it's that which draws one away from the very central elements of suspect grounds. And that's why one can't say this is akin to my sex, this is akin to my race. The fact that whether I've been in hospital for more than 28 days or not is not something that is personally innate to me. It's not something that shows someone's treating me with respect or not with respect. It's very different from those very central statuses that Lord Reid was concerned with.
Well, thank you. Now, we've got the 9 principles, and where are you taking us next? To some cases?
My lord, I'm going to give you the reference for 4 cases, and I'm going to show you just a few of the points that I wanted to show you in light of the concerns that the court has identified.
Yes. So which tabs are these cases in?
So the first one is SC itself, tab 29, page 717. Yes. The second case is A, tab 30, page 783. The third case is Mathieson, tab 20, page 465. And the fourth is Delve, tab 27, page 651.
Right.
My lord, what I want to show the court from SC, I know the court will have read it from judgments that members of the court have appeared in. I'm not going to read large chunks to the court, it's not helpful to anyone. What I would invite the court to look at is paragraph 37 onwards, in particular paragraph 44 at page 735 of the bundle, where Lord Reid does discuss the elements of indirect and fluminos discrimination. So, my lord, the section starts at paragraph 44, page 736.
Right, so how far do you want us to read at 44?
I would like you, my lord, to read from 46 to 49, through to 51, please.
Right, from 44 to 51?
46 to 51.
46 to 51, thank you.
I thought you only needed paragraph 49 myself.
My lady, that and 53 are the key paragraphs that I would like the court to look at.
Yeah.
Yes.
My lord, the point is one can't establish indirect discrimination by saying here's one case, it affects me in a particularly adverse way. That's the point I make on that. Lord Reid also gives guidance on other status. I'm not going to read that out. It's paragraph 66 through to 70. And one then looks at the question of justification. And in light of the point my Lord Justice Singh put to me, it may be worth looking at that. There is a lot of learning from paragraph 97 onwards through to 161, 162 of how one approaches objective justification. What are the key points that I take from this are the points that I've outlined to the court about what is a suspect ground. Lord Reid analyses those. I would invite the court to read 115, which is the key point of principle that Lord Reid draws from the Strasbourg cases. Then at 143 onwards, Lord Reid discusses how that's been applied in the domestic courts. And I know the court will be familiar with many, if not all of them.
Don't skate over 142. It's possibly the most important paragraph in the judgment.
My lady, I'm grateful for that invitation. I'm trying to do this very quickly so as to not try the court's patience. But
We're
yes.
all fairly familiar with SC, but it seems to me that 142 is the key, certainly in terms of the summary of Strasbourg, because that's the basis on which Lord Reid says, well, actually, you give something a label of manifestly without reasonable foundation. That's shorthand. It's shorthand for what the European Court calls wide margin of appreciation, and what we call respect for the autonomy of Parliament and decision-making in particular fields.
Yes.
And it's a convenient label, but it's not a bright line test in itself, and that's where the Supreme Court had gone wrong in some earlier decisions, which suggested that you simply say to yourself, here's the mantra of manifestly without reasonable foundation, you don't look at anything else.
Yes.
SC has redressed the balance and said, yes, it's still a useful label, as long as you understand what the label connotes.
Yes. My lady, that's right. I entirely agree with that.
Well, you say that, but I thought you were saying that it is still a test in
Well,
some
my lord,
contexts.
This is where we get into the words again. Is it a test? Is it a label? Is it a criterion? And Lord Reid uses all of those terms, in my submission, interchangeably throughout these paragraphs.
Yes.
But what I say is, what Lord Reid is not saying is that there is a change in approach between how the court has traditionally tested objective justification when one is examining non-suspect grounds, welfare benefits, and all the other factors that I've identified.
Yes.
He's not saying there's a change from Humphreys and DA when those factors are present.
No. He's saying quite the opposite. He's saying that there may be a difference in the level of, or margin of, I don't want to use margin of appreciation, but the degree of respect that is given to the decision maker in certain types of case, but where the courts have previously fallen into a degree of error is treating the test as different from from the Bank-Mellat traditional test. The Bank-Mellat traditional test is really another way of encapsulating the same thing.
Yes. And my lady, what he's not saying is that all those decisions in Humphreys, in DA, in Mathieson itself are wrong, and that one should now apply a different test to them. It's the same test when those factors are present. He's not saying there needs to be a change in approach from what the courts have done before. So when Upper Tribunal Judge Ward applied the manifestly without reasonable foundation approach, he's applying what the courts have done in DA, what they've done in Humphreys, what they've done in all the cases that led up to that point. And Lord Reid is not saying that that is wrong. He's saying that in some other cases, where there is a suspect ground, where one's not looking at welfare benefits or where one's not looking at allocation of resources, etc., you may need to apply the much stricter Bank-Mellat test with a much higher degree of scrutiny.
It's 157, 158, isn't it?
My lady, yes. And the paragraph, as I said, the conclusions
160 was the one I had in mind, which is that it's simply a different way of describing a wide margin of appreciation.
The same thing.
Yeah.
My lady, that's right. And the key, again, from the domestic perspective, there's a lot of interesting discussion, but the key paragraphs I'd invite the court to read are 156 through to 161. Whether that's now or later, I don't much mind. But, my lord, that is the point. If Lord Reid was saying that there now has to be a different approach to those traditional cases like Humphreys, like MA, like DA, he would have said so. He's not saying that. He's saying that in some cases where one is looking at, say, sex discrimination, where one is looking at cases not about allocation of resources, for example, there may be a different approach. And I completely take...
I'm afraid it's not your fault. I find this as clear as mud, I'm afraid. It is angels dancing on a pinhead. I don't know
my lord,
why
that is exactly the phrase that occurred to me when I was discussing this case.
I don't know
with
why
my people
why
yesterday.
can't we just say, and maybe you'll say authority is against me on this, why can't we just say the test is the fourfold questions in bank ballot. When it comes to applying the test, it all varies according to the context and all the factors you've mentioned and margin of judgment. All of that I appreciate. I understand. I have read this case many times, and I did try to summarise it in the Crowther case. It's not that I'm not aware of these things, but it just seems to me that we, despite the best efforts of judges to get away from semantic debates, we keep coming back to semantic debates.
My Lord, I agree. As a matter of substance, and I'm just going to summarise again what the Secretary of State's position is, we say manifestly without reasonable foundation is a test. When the factors I've identified are present, that is the correct test. If your Lordship is against me on that, I say it matters not one jot, because one gets to exactly the same result if one applies bank mallet with the appropriate degree of respect for judgments taken by Parliament.
You take the sentence at the bottom of the page where 158 exists. It's quite a remarkable sentence, which we're not construing as if it was a statute. It's remarkable because it includes the word generally, not once but twice. And so that's the sort of guidance that is being given at the bottom of 158 onto the top of the following page, that inevitably these things are highly fact sensitive, and we've come upon it seems to me, a good example here of something where it's not going to help to reach a just decision to be arguing about the extent to which this is disability or the extent to which this is disability related, because we're always going to have to consider it generally, twice generally.
My Lord, I agree with that.
I'm not arguing against you, you understand,
Yes.
but I just think we're in a sense trying to hasten to the core of this, rather than keep considering what the tests are. I know you have to do it.
Yes, my Lord, absolutely. You have my point on what I say about the test and
Yes.
what SC means.
Right, now does A add to this?
My Lord, it does, because A makes even clearer in my submission that manifestly without reasonable foundation remains a test.
Right, the paragraph reference is?
My Lord, it's at 82. The treatment of justification starts at 80, page 812, and the relevant paragraphs are 82 to 85.
Thank you.
My Lord, one sees at the bottom of paragraph 82, the appellants have accepted correctly, in my view, that the applicable test here is whether the decision to adopt the measure under challenge was manifestly without reasonable foundation. And then Lord Lloyd-Jones points to a number of features which support that conclusion, which are at 83, 84, 85. So one, it's social welfare policy. I say that applies here. Two, it's a statutory instrument that's been reviewed by Parliament. Applies here. And then three, the basis of the discriminatory treatment is also relevant here, and this is the suspect ground issue.
Yeah.
And then at the end of 85, accordingly, to ask whether the measure is manifestly without reasonable foundation is an entirely appropriate test. Well, Lord, that's the Supreme Court handing down judgment on the same day as SC, with the same members of the court. One might expect that Lord Lloyd-Jones knew what the test in SC was meant to be.
Right.
Lord, I know the court will have read Mathieson, so I'm not sure there's a great deal to be gained by going through that in any detail.
So what is the point that you would have made if we had gone to it?
The point I would have made is, in terms of identifying the status at paragraph 23, the Secretary of State has conceded that an equivalent status for adults, as was identified for children in Mathieson, is an appropriate status. And one also has at 27 the importance of bright line rules. The other point I take from
So which paragraph was that?
27, my Lord. And the final point I had from Mathieson was role of a specialist tribunal, and that there was extensive evidence about the wide impact of the rule that went far beyond the particular case in Mathieson.
It's what you usually see in Article 14 cases are exemplars which are said to be typical examples of how the difference in treatment impacts in practice.
My lady, that's right. And it's absolutely stark that there is nothing of that here. That's why I say one cannot get past the indirect discrimination element. My lord, my final point was my final case was Delve. I'm just going to give you 2 paragraph references, if I may. Paragraph 26 at page 663 is endorsing the point from Carson in UK that one has to look at the system and not just an individual case. And paragraph 41 and 42 is the role of appellate courts on appeals against conclusions on proportionality.
Thank you.
So, my lord, turning to the grounds, on status, I'm going to deal with this very, very briefly in light of your lordship's indication. The status that the Secretary of State accepts exists is at paragraph 5 of the judgment of Judge Ward, page 23 of the core bundle. We accept that Strasbourg and the domestic courts give a broad and generous interpretation to an other status, but we say there are and must be some limits to that concept, otherwise the text of Article 14 doesn't mean anything. All one gets is simply a difference in treatment and justification. We say when something is immutable and can't be changed, that's obviously another status. Some statuses are capable of changing over time, such as residence and employment, but one can't have a status where we say it can change from minute to minute, from hour to hour, from day to day. The status has to be stable and durable and capable of being identified easily in order to be a status. And I've taken the court to the terms of the Mental Capacity Act about how one gets to a determination in domestic law that an individual lacks the capacity to make a decision about a particular thing at a particular time. We say the Mental Capacity Act is not a status-based system. It is a change to a functional approach to disability, and it would simply be an unworkable system to have to carry out an assessment to work out whether an individual has the relevant status or not before this rule could be applied. We say it would breach the mirror principle to so find, and it's not an incremental development. The only cases where Strasbourg has mentioned capacity are set out at paragraph 49 of our skeleton argument. I'm not going to turn them up because Miss Weston didn't, but you have what I say about each of those 3 cases in our skeleton argument. So in summary, we say Judge Ward was right to reject the alternative statuses that were put forward by the appellant. The way it's been advanced today doesn't take matters any further forward, because whether one defines the status by reference to a deputy or whether one defines a status by reference to a functional inability to take a decision, the only way you can do that in domestic law is under the Mental Capacity Act itself, and to determine that's the only way in which one can assess whether an individual is unable to make a decision for themselves. The fact that this claimant, it is unlikely that he would be able to recover capacity to take certain decisions.
Still,
is
I'm torn between wanting to get on and wanting to understand.
But look, that's also my concern.
Just at the moment, I'm just not understanding why a person with severe disability that encompasses an inability to make decisions for him or herself.
Yeah.
Why that state of affairs is not worthy of the name of a status.
Well, my lord, it's because of the changeable nature of it. I think Judge Ward described it as being
No, it's not. I mean, I'm sure that the gentleman in this case would wish that he had a changeable condition. He doesn't.
But my lord, one's not only looking at this gentleman in this case. If it's recognised as a status, then it will apply to all cases where individuals
a person whose disability encompasses an inability to make decisions. I mean, clearly there are different sorts of disability. For example, one can, with various degrees of gravity, be blind, or one can be limbless, or one can be somebody who lacks the mental capacity to make choices for him or herself. So I'm just not so far grasping why you have to lump everybody with a disability in together. Why one can't just look at the circumstances of a not insignificant group of people who have a certain sort of disability.
Well, my lord, one can certainly do that. I'm not disputing that for a moment. And there are a number of cases that say that different degrees of disability can be a status. There was a case I did in front of Mr. Justice Mostyn a few years ago called RF for the Secretary of State for Work and Pensions, where the Secretary of State accepted that people with a particular kind of disability and people with a different kind of disability are respective statuses. The nature of the disability can be a status. But that's not Miss Weston's case. Miss Weston's case is the status is severe disability, long-term inpatient in a hospital, and lacks the functional ability to make a decision. And it's that bit, because the Secretary of State has accepted the first two bits as being a status, it's that last bit that we say goes too far. It wouldn't be recognised by Strasbourg, it hasn't been recognised by Strasbourg, and
Well,
it's
maybe it
never
hasn't-
been recognised by
maybe it
these.
hasn't come up. What's the difference? Because there is a difference between this gentleman and the person in the next bed who happens to be very, very severely disabled so that he can't do anything at all for himself, but he can tell everybody exactly what he wants. There's a difference, isn't there?
Well, my lord, there is a difference, yes, but it's not. Article 14 doesn't protect against every difference in treatment. That's the point. One needs to get it within an other status in order for Article 14 to apply. And what we're looking at here is, well, what can constitute an other status for these purposes? And the Secretary of State has accepted that severe disability and long-term inpatient in a hospital can be another status. It's just this element on top, because of the difficulties in applying functional inability to make decisions under the Mental Capacity Act. And, my lord, what I do say, I haven't turned the cases out, but I would invite your lordship to read what we say about them at paragraph 49 of our skeleton. Those are not cases where the Strasbourg Court identified the status as being capacity, lack of capacity. They recognise the status as being disability. And that's important. The two cases that have come there from the UK, the status was disability, and it's looking at how the disability impacted on particular measures, not disability and capacity, because we say capacity is so difficult to apply as a status.
During the course of today, I think it's become clearer, certainly to me, that what Miss Weston has focused upon is not any incapacity, but what she called state-ordered or state-acknowledged incapacity. And she gave as the prime example of that, where the state itself has, through a court order, decided to appoint a deputy. That may not be the only example, but that may be the only example she needs. But here we have that. Why isn't someone who has a court-appointed deputy occupying a different status from someone who doesn't have such an appointee?
Well, my lord, that's where I was making very careful notes when those questions were being put to Miss Weston, because I had had some difficulty before today understanding what exactly the status was. And if the status is looking at a deputy, that may be that it is something much easier to ascertain because there is an order that has been made by a court which makes that finding. I accept that. But that's not the status that, as I understand it, Miss Weston is advancing.
Well,
My
it is
lord,
now.
well,
I think.
my lord, I don't believe she was.
was.
My Lord Justice Peter Jackson put to her, is this solely about being a deputy? And the answer was no. So,
Well, all right, that's a fair comment. But what's the answer? If I put it to you, right? I mean, maybe it's wrong, but what is the answer to it? If I say to you, why is that not a status? What's the answer?
my Lord, I think one, that's not a case that's ever been put. So I don't have instructions on it. Two, standing here on my feet, what I would say is that doesn't take account of the nature and extent of the disability that the individual has, for the reasons that I think I gave in answer to my Lady Justice Andrews, that one can have people with the same nature and extent of disability, but it's a happenstance whether there's a family member who wants to or is prepared to act as their welfare deputy and goes through the difficult process of making the application to court and getting such an order. So it's not focusing on the nature and extent of their difficulties or their needs, which is usually what Strasbourg is concerned with in this context. So it is more easy to identify than functional inability to make decisions, but it may not be getting at the heart of the difficulty, if I can put it like that.
Thank you.
My Lord, there is more I could say on status, but we've said it in our skeleton argument. I'm not going to do it on my feet, given the time, and there are many other points that we need to consider. So what I'm now going on to deal with is, even if you are with Miss Weston on this point of status, can she show that Judge Ward erred in law in the way he approached the comparative exercise and the findings he made on objective justification? She invites you to remit the matter for further facts to be found. We say that's not right because the judge went on to consider whether there was any prima facie case of discrimination and to consider objective justification in case he was wrong on the issue of other status. So, my Lord, looking then at whether there is, one can even get over the hurdle of is there any indirect discrimination. Now we're in the field of there's a neutral rule. Does it have a disproportionately prejudicial impact on the group that falls within that status? So we're working on the assumption that the status is either a deputy, as my Lord has put to me, or the functional inability to make decisions. And the two ways that the appellant has put this case over time is that either the family member is required to provide the care because they best know how to meet P's needs. That's how it was put in writing. That's now no longer being pursued, as I understand it. It's now being said that the lack of capacity means that all individuals in that position will need a decision maker there, or someone there in the hospital, to represent P's interests or to protect his autonomy. And it is said that removing the care component of DLA has the effect of preventing a deputy from taking those steps which Miss Weston says the deputy is required to take. We say there are two fundamental problems with that analysis. The first is the one that I've highlighted, in that Judge Ward and this court only have evidence about this individual appellant. You have no statistics about how this might apply on a much broader, how the rule would apply on a broader basis. There was no evidence put before the first tier tribunal or the upper tribunal about how many individuals are subject to the hospitalisation rule, how many of those may lack capacity in the relevant way at the relevant time, or even how many of them had a welfare deputy appointed.
So this was all in contrast to Mathieson.
It's all in contrast to Mathieson, my lord. And there's no evidence, as the court had in Mathieson, from other individuals or from charities who are involved in this field, who work in this field, that says this is not just an isolated, hard case, hard facts case, and this impacts on the rule as a rule.
Well, the evidence here is even thinner than it was in Salvato, and it was a stumbling block in Salvato. At least in Salvato we had some evidence from charities, but here it's just one example. No statistics, nothing.
My lady, that's right. And what I would say in response to that is that the courts have made clear, both in Strasbourg and in domestic courts, that there can be bright line rules. There can be bright line rules that cause hard cases, but an Article 14 challenge is a challenge to the system. It is a challenge to the rule as a whole. And one can't do that in my submission. One can't find that the rule, the legislative provision, is unlawful, breaches Article 14, based on the facts of an isolated individual case.
You have to show a focus on disproportionately prejudicial effect on people within that group.
Yes.
So you can do that sometimes by showing that people within that group find it less possible for them to be able to meet the requirements of a rule. And there may be some cases in which it can be shown that it has a particularly egregious effect upon them because it impacts on their ability to act in a particular way.
Yes.
And I think Miss Weston is sort of veering towards the latter rather than the former, on the basis that her case is that it impacts adversely on the ability of somebody like her client to be able to avail himself of the services of the person who is tasked with making the decisions for him that he can't make himself.
Now, my lady, there's a number of responses to that. First, that is dependent on there being a deputy, because it is only the person tasked with making the decisions is only when there is a deputy.
Yeah.
We know that the deputyship orders are very rare. We've seen from the Code of Practice the circumstances in which those orders may be made. Secondly, one then has to tie that back into the payment, because it's a payment that we're concerned with here. And that's why I made the submissions about what the role of the deputy and how a deputy is remunerated, because one can't use DLA to pay a lay deputy for performing that role.
I thought you could use DLA to pay for anything. You could put it on the 955 at Kempton if you really wanted to.
Well, my lady, yes, but the deputy is not entitled to remuneration. A lay deputy is not entitled to remuneration for acting as such. And one can see the obvious conflict of interest if that were to occur.
Yeah.
A professional deputy can be paid. There are strict rates on payment. It's supervised by the court and things of that nature. But a lay deputy can't take funds out of the person's account to be paid for performing that task.
Was this the second of your two fundamental problems?
No, that was still my first point, my lord. I've just expanded on that.
Right.
My second point, it relates to the evidence and the findings of fact that Judge Ward made. Judge Ward rejected, on the evidence before him, any disproportionately prejudicial impact. He found as a fact that the argument that P required another person present because he lacked capacity wasn't made out. And, my lord, one can see that by looking at the findings that the judge below made. Again, I don't want to read large chunks of the judgment that I know you've already read, but one sees from paragraphs 21 through to, paragraphs 13 rather, through to 27, one sees the findings of fact that Judge Ward made. So first he focused on the care needs, and are those care needs being met by the NHS? He said they were. There's no evidence, he found at paragraph 15, that the system that DWP had described was not working. So paragraph 15, the lack of evidence to counter what the Secretary of State had described is striking. There's no evidence the system is not working as it should. One sees the discussion of the fact sheet, the letter from the social worker, the letter from a professor who said he was happy with the care. And paragraph 21, the conclusion that he's not satisfied that in general family members are required to assist in the way that has been described in providing care to a person with learning disabilities who is in hospital. Now, Miss Weston might say, well, that doesn't cover the list of things that she says should be covered. But, my lord, that's because that was never put to Judge Ward. That's not the way the case was put. But what he's finding as a fact is there's no care needs, and there's nothing, the deputy is not required to be there to perform the deputy's duties. He finds that as a fact, so paragraph 22. It doesn't make a material difference the person's acting as a deputy. yes, they need to have an understanding of the patient's needs and wishes, but it does not follow that it has to be acquired from a hands-on care role. So the deputy doesn't have to be there in the hospital every day. And my lord, that's the point that your lordship put to Miss Weston. The suggestion that that's how a deputy performs their duties would be met with abject horror, I suspect, by the deputyship community. But the responsibility, the last paragraph of 22 is very important. The responsibilities of the deputy are cast in terms of taking decisions rather than the direct provision of care. And again, that's why I took your lordship and your ladyship to the Mental Capacity Act, which sets out what it is that the deputy has to do. It's to make a decision on behalf of P. And where the deputy is not there, the decision as to care and treatment is made by the providers of that care and treatment under Section 5. There's nothing in the Act that requires a deputy to be there to give consent every time a care provider wants to provide a tablet to P or medicine or turn him or touch him or anything of that nature. So, my lord, Judge Ward then went on at paragraph 23 to deal with the evidence that was in front of him about what was done. This is the evidence about providing advice to carers, to attend meetings, to do the facilitating, to do the communicating. And Judge Ward makes the findings of fact in respect of that. It's a very positive thing that the deputy is doing. It shows her commitment to her brother. Of course it does. But there's nothing that says that that is a wider spread issue or that it was a requirement. So the judge deals with what was said in the fact sheet. He takes it at face value, deals with all the provisions, all the things that the deputy was doing. And he makes a very valid point at paragraph 25. The sense of responsibility, love and concern for her brother led her to perform those duties in an exceptional way. But it's the last part of that paragraph that's very important, I say. The lawfulness of the hospitalisation rule cannot be determined by what may come to be done in an individual case, irrespective of what is objectively required. And my lord, what the judge then goes on to do is to say, well, was there an impact, or what was the impact of removing the care element of DLA? And they draw the contrast with Mathieson, where the individual family there could demonstrate a loss and increased expenditure. And again, the finding of fact made by the judge, which hasn't been challenged, the end of paragraph 27, the appointee has not succeeded in demonstrating expenditure that could not be contained within the means-tested benefits remaining available. Because, of course, it's not, DLA is just one of the series of benefits that is available to MOC and to his family. So, my lord, one then sees at paragraph 30 from the judgment the distinction drawn with Mathieson, and the judge is again finding a fact that it's not, even if, contrary to the findings he'd made, that the amount of care and presence was required in this particular case, there's no evidence to support a generalised requirement at such a level in respect of a patient with severe learning difficulties. And on that basis, the present case should be seen as a hard case falling the wrong side of the bright line rule. So, my lord, that's how the judge approached indirect discrimination. And I say, one, there's no basis to show that was an error of law. But two, even if this court were finding that we're making the decision for itself, this court has no evidence on which you could find a disproportionately prejudicial effect of the hospitalisation rule. And that, I say, is the end of it. One never gets to objective justification if you're with me at that point. So, my lord, all the interesting discussions about what does SC mean, about the appropriate test, we simply never get there, is my primary submission.
And the same is true with Flimenos, because he makes similar finding at the end of 32.
Yes, my lady, you've anticipated where I'm going next. It's a finding of fact.
Yes.
There is no significantly different treatment.
That has failed on the evidence, are the words he uses.
My lady, yes. And I say there's no challenge to that finding on the evidence. There's no perversity ground of appeal being advanced here. There's no appeal on the basis that there was no, the judge made findings of fact that weren't open to him. Those are the findings of fact. And so I say my primary case is you just simply don't get to objective justification at all. Now, my lord, my fallback position is obviously if you do get to objective justification, I get home anyway. My 3 preliminary points on objective justification, one I've just made, you don't get there because you haven't got over the indirect discrimination and anything else arguments. 2, if you do get there, then all the points I've just made about comparators, I say are shifted into the objective justification analysis, and they go to whether there's a fair balance that has been drawn.
Forgive me for interrupting you, but is the fact that the ground of complaint is indirect discrimination itself a factor? I'm not saying conclusive factor, but a factor. Instinctively, it feels to me that it must be, because if you directly discriminate against black people, somehow that feels instinctively to me as requiring, well, probably it can't be justified, but instinctively it would certainly require much more cogent justification than if something happens to be neutral but has a disproportionate impact.
My lord, yes, and in SC, Lord Reid does make the point that the indirect discrimination jurisprudence from Strasbourg is still relatively in its infancy to some extent.
Yes.
And he does make the point that indirect discrimination cases have been confined very much to limited grounds. So indeed, he couldn't point to a Strasbourg case that had found indirect discrimination on the basis of disability or age, for example. They had all been sex or race. My lord, I'm trying to find the reference for your lordship, but there is definitely a discussion.
I remember that.
Yeah. My lord, I don't say the fact that it's indirect discrimination means that it's more likely to be manifestly without reasonable foundation, because a number of the cases that Lord Reid relies on were indirect discrimination.
Yes, well, that's
You can't justify direct discrimination.
Well, my lord, you can under Article 14 terms. Yeah. You can't in domestic law and under the EU, but you can under Article 14. It's much harder to do, but you can do it.
Right, I understand.
Well, that's all I was trying to get.
Yes.
It's much harder to do.
Yes, but my lord, when one comes to what one is justifying, and I do have to deal with that, Miss Weston said one has to justify the difference in treatment. Now, that's right if one is concerned with direct discrimination. One has to justify why you're treating a black man differently to a white man, as your lordship just put to me. But here, one has a neutral rule. What one is justifying, regardless of what the status is one is justifying the rule.
Yes.
This is what I was really getting at.
Yeah, I do apologise.
No, it's my fault.
Your question.
It's my fault. Just a matter of judicial instinct. And it could be a bad instinct, which is why it needs to be tested. It just feels as if.
We found it in Salvato.
Yeah, my lady, I was just going to give that reference. Just the point, perhaps if I just deal with the point my Lord Justice Singh made. The Belmarsh case that my Lord gave as an example was obviously direct discrimination. That's why you're justifying the difference in treatment. AL Serbia, that Miss Weston relied on, was direct discrimination. But my lady, your ladyship dealt with this point in Salvato.
And it was on the basis of something else Baroness Hale said in another case, the name of which I forget.
Yes. My lady, it's paragraph 94, page 878, where my lady makes that very point. One is justifying the measure, not the disproportionate. Because one can't justify the disproportionate impact because it's the measure that Parliament has enacted, not the difference in treatment. It's the measure. If you can justify the measure, then it's not unlawful.
I'm not sure about that. Jurisprudentially, as a matter of principle, if there was a very severe impact on a minority community, say, then one would still have to do the fair balance test and the question 4 of Bank Mellot.
My lord, one still would do the fair balance test if one got to Bank Mellot, but one is still, the question is the measure objectively justified? That's the point I'm making.
No, I'm questioning whether that's right. I'm afraid it may be right. I'm not sure. I'm not convinced it is right, because you would still have to justify. You'd have to conduct a fair balance exercise whether, despite the discriminatory impact on a minority group, it was still fair to uphold the measure.
My Lord, I accept that. I don't think we're in a disagreement. Again, it's just the language.
I see.
I say you justify the neutral rule, but as part of that justification, as part of the sort of fair balance proportionality analysis, one is looking at, are the positive reasons for the rule,
Yes.
do they outweigh the particular impact it
I
might
see.
have?
Right.
But
Or
one is
in-
still justifying the rule.
Or
the neutral
indeed, could the legitimate aim that the rule is aimed at be achieved without the disproportionately prejudicial impact that it has on the status on the group that is adversely affected? That's another test that is often applied.
Yes.
Could you achieve that aim by a less intrusive, less potentially prejudicial means?
My lady, that's right, and that would be the third stage of the Bank-Mellon
Yes.
test. But with the large caveat that the third stage of Bank-Mellon means what Lord Reid said it means in
Yes.
paragraph 75 of that case,
Yeah.
that it's not for the court to be able to identify different ways of achieving the objective.
No.
It's was it reasonable for Parliament to do it in that way.
Yes.
Well, although those are the three preliminary points, which I hope we are now clear. Then turning to the substance, Miss Weston put the case I put the case in two ways, which I've already highlighted. I say first, the judge did apply the correct test, the manifestly without reasonable foundation test. He applied it to the facts that he had found, which are unchallenged. And there's no basis, I say, following Delve and the approach that an appellate court should take to a finding on proportionality, there's no basis for this court to interfere with the balance that was drawn and the conclusion that was reached by Upper Tribunal Judge Ward. That's the first way I put it. It's for the three factors that I've already... I say he made the right test for the three factors I've already identified. I'm not going to repeat those now. I think the court has a note of those. But, my lord, even if that was the wrong test, then I say it makes no difference because one simply applies Bank-Mellon with the largest possible degree of respect to parliamentary choice because of all those factors. And so, again, there is no basis to depart from the conclusion that he reached. It's simply a matter of labelling.
Yes.
Lord Reid himself says there's not going to be any difference between manifestly without reasonable foundation and Bank-Mellon with appropriate degree of respect. If we do get to the point where this court thinks they need to take, your lordship and your ladyship think you need to take the decision yourselves, then I say it's obvious what the decision is. The measure is pursuing a legitimate aim, and that's avoiding the duplication of public funds. And that's tied to, well, what is the purpose of disability living allowance to make a contribution to additional costs arising from disability. Those are not being incurred when in hospital, when those needs are being met by the NHS. Ms Weston put it that there's not even a rational connection between that aim and the rule, and yet she was forced to accept that many of those needs, or sorry, I may be overstating it, but at least some of those needs are being met by the NHS while the person is in hospital. So it can't possibly be said there's no rational connection between the rule and the aim. Ms Weston accepts that there is some. Then with Bank-Mellon, one would ask, is there a less intrusive measure? Well, I mean, one asks rhetorically, how could the Secretary of State make a lawful rule on Miss Weston's case? She says one disapplies the rule for MOC, but then says she's not advocating a position where the Secretary of State has to disapply the rule on an individual basis for every individual who lacks capacity. So of course that must be right. That would be completely unworkable. So then how does one do it? If the status is lack of capacity or inability to make a decision, how does one do it without asking the decision maker within DWP who takes these decisions to somehow make a finding about whether an individual has capacity to make a decision about care and treatment while they're in hospital?
Well, you'd have to, if you don't use the deputy as the proxy for the degree of disability, I agree with you. if you do use the deputy as a proxy for the degree of disability in terms of capacity to decide things, then I suppose you could say, if you were on Ms. Weston's side, you simply have a rule which says that the clawback or the benefit continues to be paid for everybody who's got a welfare deputy.
My lady, my response to that is I think the point I've already made, that is not linked to an assessment of need. It doesn't identify those with the most complex needs. It's simply those who lack capacity the court has found and have a family member who's willing and able to take on the deputyship role. So you could have a scenario where you've got two individuals with exactly the same level of need, with exactly the same presentational case as Miss Weston puts it. One has a deputyship or one doesn't. One can see the next Article 14 challenge.
Yes.
And what one has, I come back to it, is a bright line rule that the Secretary of State has adopted, that's been endorsed by Parliament, that has been prefaced in primary legislation since 1945, as being a simple and workable way of operating this system. There may well be hard cases that fall one side or other of the line. This may well be one of them, as Judge Ward recognised. But that, in my submission, does not make this rule manifestly without reasonable foundation or the fair balance applied with the appropriate degree of respect for...
In a case of this sort, just for my curiosity, in seeking recoupments and penalties, does the Secretary of State have any degree of discretion?
My instinct is yes. May I just turn my back for a moment, my lord? My lord, your lordship probably heard that. The answer from behind was, we're not sure, but we think that the Secretary of State has a discretion. Right. That is my understanding, given the way the recruitment provisions usually work. It's not a duty to recoup, it's usually expressed as a power to do so.
Have I understood the facts correctly, that the requirement to pay back the overpayment has been suspended pending the appeal?
Yes, that's my understanding. Yes, I get lots of nods behind me for that one, my lord, yes. And of course, the other point that, I don't know if the court's aware of this, but MG still had the use of the Motability card throughout the process.
Do we, amongst all the papers, have the, maybe that this can be produced later, a record of the fact that the repayment was, as it were, stayed or suspended, whichever it is? Is that amongst our...
My lord, I believe it's in the supplementary bundle.
Page 109.
Oh, thank you. I'm told 109.
Yes, thank you. Yes,
Page, sorry?
Page 109.
Thank you very much.
Bundle, paragraph 50, last sentence. Since we're on that witness statement, can I ask you a couple of questions arising from it? On page 109,
yes.
Under the heading Administration of DLA, at paragraph 53, that's really making the point about, as it were, that's stating in evidence what you've said in submission, that there is an important context to this, which is that for sound administrative reasons, it's meant to be a relatively simple system. That's why you need the bright line. Is that right?
Well, Lord, that's right. And that was in evidence before Judge Ward, and that's the evidence he accepted.
The other thing that was in evidence before him is at page 106, at paragraph 42. And he did make reference to this in his judgment. And that's the cost that there would be if you had to change the legislation. I was just wondering what the Secretary of State's submission is. You may not be in a position, because I don't know. What is your position? Are you relying on the cost as well?
Well, my lord, that's part of the double funding element. So that's the cost of DLA. If you don't disapply it, that's going to be the cost to the public purse of continuing to allow those who are having their needs met in hospital to continue to have DLA.
Yeah, the slight difficulty is, and I don't criticise anyone for this, let me emphasise, the slight difficulty is that because the nature of the complaint has changed over time, including in this court. I suppose depending, if the legislation did have to be changed, it would depend on what the new category of recipients is. So we don't have any evidence, actually, of what the financial cost of any decision we make would be if it were favourable to the appellant, because no one's had the opportunity yet to work out exactly what the cost would be. Is that right?
My lord, that's right. This evidence was put in to meet the case as it was advanced
Right.
before Upper Tribunal Judge Ward. The case has gone through many different permutations since then. And indeed, if it were to be very narrowly confined to those with a deputyship order, the costs are likely to be much lower because there are so few people who actually have deputyship.
Yeah, that's a fair, as always, Ms. Claimant, that's a fair point you make on behalf of the government. But could we at least take judicial notice to this extent, that whatever the exact nature of any future change of the legislation were, one can be certain of this much, that it would require the state to spend more money.
My lord, absolutely, and
therefore,
significant sums of money.
Yeah, and therefore,
millions.
Therefore, on your submission, we are very much in the territory that Lord Reid was talking about, and many courts have spoken about, that it's one thing to say, as in Belmarsh, the state can't lock up people on discriminatory grounds. It's a different kind of decision that the court is making. And he did caution us not to get too close to the political arena.
My lord, that's right. I was going to mention paragraph 162 of his judgment, where he does just that, particularly in cases in the social security field, where one, by definition, has to apply neutral rules on a systemic basis, which is exactly this kind of case, with considerable public finance implications. My lord, unless I can assist further, those are my submissions.
Thank you very much indeed, Ms. Claimant. Yes, Ms. Weston.
My lords, my lady, there are just a few points I wanted to come back on, if I may. Firstly, a short point dealing with Section 19 of the Mental Capacity Act and reimbursement. It's not been part of my case that remuneration is sought. This is, it relates to the cost of providing the services for MOC and whether reimbursement is appropriate. And statute says it can be, it is appropriate. It may happen, but it's not about remuneration. There's no sense in which this carer is asked to be paid, merely that her expenses should be covered, and that she should be able to provide the service in the way that she did previously. On the question of the Upper Tribunal Judge's judgment, it is my submission that one would expect to find in the justification part of the judgment some reference to additional needs arising from incapacity and the evidence given by MG as to how she meets those and what those additional needs entail her to do. But there is no mention of that. It's very much focused on, I'm not going to take the court through it again, it's very much focused on hands-on care and whether she's required to provide hands-on care, and everything else is referred to in quite dismissive terms as things that a relative would do. One would expect to find in my respectful submission, had the judge properly considered the role of capacity to play in the status, one would expect to find somewhat more consideration of those additional capacity.
Taking it in stages and starting with the first tier tribunal.
Yes.
Did the first tier tribunal sufficiently accurately identify the nature of the case that was being put about this?
Yes.
So just so we can crystallise your concern about the later judgment, could we just put our finger on the paragraphs I'm looking at around page 112, 113 of the full bundle. Could we crystallise what paragraphs the FTT got?
The FTT.
Yes, I'm looking at the FTT, trying to see how they summarised and grasped the case that was being put to them on this particular
Yes.
issue. Which are the paragraphs that you would say?
If we see at 112 of
Yes.
the bundle page, under the appellant's case,
Yes.
we can see that it was her position that that he required care and supervision at a greater level because he's been and still is in hospital. And then just dealing with the facts and MG's continuing role in the treatment of MOC, we can see that the court refers to the 2-page submission that I've already taken the court to, and then finds over the page that
I'm really, I think, just asking you to give us some numbers.
yes, the tribunal accepted that MG continued to play an important
17.
part in 17, yes.
Yes.
And at 19,
Right, well, is it really 19?
yes, this is a summary of what's set out in the 2-page document that I took the court to previously, which goes into a bit more detail on.
No, but I mean, essentially, it's the non-physical care
Yes,
aspect to it,
indeed.
right? So is it your submission that the Upper Tribunal failed to grasp what appears at paragraph 19?
Yes, of the findings of the first tier tribunal. Yes, it is, my lord, yes.
And
In addition,
what, by having misunderstood the case or by having, as you put it previously, downplayed it?
we don't
I find it hard to-
we don't find those findings reproduced in his reasoning, and he bearing in mind this is a nuanced test, a nuanced consideration, one would expect to find those findings reproduced rather than as he summarised the material at the bottom of paragraph 31 of his judgment, and he says there's no indication. I'm so sorry, I've got the wrong paragraph which I've highlighted. Sorry, my lord.
Can I help you? Just going back to page 27 and paragraph, in paragraph 13,
Yes.
the Upper Tribunal judge quotes at some length from the medical policy advisor
Yes.
in the DWP, dealing with this hospital. And then at paragraph 12 and 13, in particular paragraph 13, the sort of support that is provided by relatives, which goes beyond physical care, because that's emotional support. So the judge was clearly alert to that because he quoted it.
Yes, but emotional support that a family member provides is qualitatively different to the task of a deputy whose job it is to facilitate and protect in all the ways that I've explained previously a person who lacks capacity in order to render their situation as equal as it can be for somebody who doesn't lack capacity. And one would expect to see that evaluation in the Upper Tribunal judge's reasoning and justification.
All right.
The other point I would make is that the fact sheet, which is referred to obliquely by the judge, but the detail is not reproduced in the judgment, did set out in detail, and we see at page 70, from 69 to 72 in particular of the supplementary bundle, a great deal of detail, including practical examples given by MG, and we don't see how the judge dealt with those aspects of MG's functions. I'm looking in particular at page 72.
This is commented on in paragraph 24
Yes.
of the judgment.
Yes. So, so we would say there was detail, and we bear in mind, of course, that the Upper Tribunal is an inquisitorial process. There was detail in front of the Upper Tribunal judge, which had a direct bearing on the capacity-related needs of MOC. And it's material, we say, that although the court is right to note that at paragraph 10, 11 of the judgment at page 25, the judge went on to deal with justification in the alternative. One of the reasons he gives for doing that is because the claimant was conceded to have one status, one which is not defined, that says defined, right? I read it as defined, by reference to any lack of capacity. So it's not at all clear that the judge's approach to the justification exercise wasn't influenced or skewed by his error, we say, on the question of status. So the submissions I'm making only really arise if the court agrees with the appellant that the judge went wrong on status.
Well, that's his treatment of the evidence that was before him. But don't you have to overcome the hurdle in the first sentence of paragraph 24, where he's made a value judgment as to what weight to attribute to that evidence?
Well, in my respectful submission, it's wrong for him to simply say, in broad terms, it explains that the appointee and family had a role in interpreting communication.
Yes, you're ignoring, with respect, Ms. Weston, you're ignoring the point I'm making, which is the first sentence. The question of what weight to be attributed to evidence before a fact-finding tribunal is for the tribunal. And what he has said is, on the basis of the format and content of the fact sheet, it's difficult to place heavy reliance on it. Now, that's a matter for him, isn't it?
Well, we would say that he went beyond not placing heavy reliance upon it. He doesn't refer to a great deal of its contents.
Right.
Do we have to bear in mind that this is a second appeal?
Yes.
And that the only basis, as I understand it, on which permission to appeal was granted by the Upper Tribunal itself was that it raised an important point of principle.
Yes, yes. It might be helpful to turn up the grant of permission by UTJ Ward at this point.
Page 108.
It's which is towards the back of the bundle. It's at 108.
Yeah. So that's what the appeal is currently about.
Yes.
And I know you've got an application to amend your grounds, which I do want to ask you about in a moment.
So it's clear that the judge considered at paragraph 4 that it's the relationship between lack of capacity and status is plainly arguable as a point of law. It wasn't just a question of the wording of the proposed status. What the judge was concerned about is what role capacity had to play in light of the grounds.
You may be right about that. But is there a document in this bundle which tells us what are the grounds of appeal on which he granted permission? Because that governs the scope of this appeal currently, subject to your application to amend the grounds, which I do want to come back to.
Yes, it's at page 99.
Page 99. I'll just check that again. That's an application.
Yes, it sets.
Where are the actual grounds?
They start at the bottom of page 99. Grounds of appeal, ground 1.
So if I were to go through this document and look at the underlined parts, which are the grounds, that's what he's granted permission for.
Yes.
Right.
Except that now ground 3 is gone.
Well, before we get to what's gone, this is what he granted permission for.
That's right.
Yeah, but he didn't grant permission for the sort of submissions you've just been making, that there was an error of fact, for example. And he wouldn't have done, because that clearly doesn't raise anything like what's needed for a second appeal to this court.
He specifically granted permission in respect of justification, and we see that in his granted permission. He said at 108. Over the page 109, sorry, I would not give permission to appeal unless I regarded the ground of appeal challenging the conclusion on justification as also being properly arguable. I do so consider.
Yeah. I had read that to be a reference to grounds 1 and 3.
My understanding is that...
As formulated in front of him. Because ground 2 relates to status. So he gives permission to argue that, and he's less sure, but he says, I grant permission on, effectively he's saying, on the 3 grounds which have advanced before them. All right, but anyway, can I just turn to understand what the application to amend is about? Because I've got 2 documents in the core bundle. There's one at page 17, which is headed Amended Grounds of Appeal, but has track changes. And then behind the next tab at page 19, there's a document also headed Amended Grounds of Appeal, this time without track changes.
I think if we start at 13, we've got the document which is the application to amend,
Yes.
which gives the narrative.
Yes, I appreciate that, but I just wanted to see what the grounds are, because, well, can you help me, Ms. Weston? What exactly are the grounds that you currently wish to advance before the court by reference to a document?
It's the document at page 19. That's
Right.
the clearest version because it has no track changes on it.
No, that's very helpful. So, just to be absolutely clear, ground 1 is erred by failing to hold a right. In particular, subground 1, that's the status point.
Yes.
The second point is the Mathieson point, and the third point you have now abandoned.
Yes, as it relates to, we don't abandon justification plainly, but we don't make a comparison with 16 and 17.
That's very helpful.
I think we started off on this by asking what part of the grounds, either as granted or as sought to be amended, has got anything to do with challenges to findings of fact.
It's our global submission, as I put, that one of the consequences of misdirecting himself as to the status was that the findings were incomplete. They didn't capture all the matters that the court should have had regard to if the court has accepted that the capacity element of the status was appropriate.
Okay, that's the submission. Yes.
Can I just turn my back for a moment?
Anything else, Shelley? Anything else?
Unless I can assist the court further, those are my
No, thank you very much indeed, Miss Weston, and to those who support you, and to all concerned. We'll take time to consider our judgments. We'll let you have them in the usual way, for the usual sorts of corrections under draft order, please. If there's anything that you can't agree in the draft order, then you will make some short written submissions, and we'll decide that without the need to trouble you either about those, unless we really need to, or about attendance for the hand down of our judgments.
My lord, before you do rise, we do still have outstanding the application to admit the fresh evidence and the application to amend the grounds.
Yes, well, I think we can. I think those are matters which I indicated we would, as it were, take in. Do either of you wish to make any specific submissions about those, or are they, in a sense, consequential upon our conclusions?
My lord, in terms of the witness statement, no one's ever turned it up, so no one's been asked to look at it during the course of the hearing, so I say it's superfluous. There is still a lad and marshal point, but no one's had to look at it, so I think it falls away.
Yes, well, we are hardwired for lad and marshal, so
yes.
Goodbye.
My lord, in terms of the amendment, I think the position's been set out in our skeleton argument that if it necessitates fresh evidence, it's something that the court should refuse. But if it doesn't, then the court's heard the argument on it today, so the court's in a good position to decide whether to accept it or not.
Well, I think it's useful to... sorry, you were going to say something, Ms. Weston?
Yes, just very briefly.
Yeah, of course.
We have set out in quite a lot of detail how we sought at a very early stage in these proceedings to try and expand on the role we said capacity played in the status argument, and we did that by way of an amendment. In fact, it was more in the nature of a clarification, because what we really sought to do was to set out as fully as we could at the earliest stage what we were saying about the point raised by, or the point as expressed by UTJ Ward in the grant of permission, which is the relationship between capacity and status. And so we say that there's nothing new about the point, it's simply trying to clarify it as clearly as possible in time at an early stage in order to assist the court and the Secretary of State.
No.
So
Well, thank you, and this has been a reminder that we won't overlook the applications to amend or to add to the evidence when we come to give our decision.
All the explanations about why the application to admit the witness statement has been made are set out in writing. I don't add to them now.
No. All right. Thank you. Stand, please.